Thank you everyone for joining us today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. Today we're going to spend some time talking about the EB2 NIW, which is short for National Interest Waiver, which is a green card pathway that allows self-petitioning for certain individuals with advanced degrees or exceptional ability. As we will discuss in the presentation today, this can be a great option for entrepreneurs. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we do have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based matter, employment-based matter, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will be sending out a copy of the PowerPoint that will be used in this webinar today. Second, we will also send you a comprehensive guide that you can use as a resource on the NIW and the requirements. We will also send you a link that you can follow where you can sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button as we do regularly upload a variety of immigration law related videos and tips and tricks. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced attorneys, including myself, if you wish to discuss the specific circumstances of your case further with us. So today I will be presenting about the EB2 NIW. I have a wealth of experience handling a wide variety of EB2 NIW cases, and I will be sharing my insights on how you can qualify for a green card under the EB2 NIW category. Finally, for any questions you may have, please feel free to add them using the chat box or the Q&A function, and I will try and get to all questions. So without further delay, I will get started. All right, so first, let's talk a little bit about the basic requirements for the NIW. Now, as a general matter, the NIW, as many of you may already know, is short for National Interest Waiver, and it is a subset of the EB2 employment-based immigrant petition. Now, immigrant petition means this is an application for a green card. So you are applying for U.S. permanent resident status. And a green card gives someone the ability to live permanently in the United States and work for any employer or not at all. And having a green card is also attractive because it opens up the pathway to U.S. citizenship in the future. Now, generally, the EB2 NIW is a popular choice among individuals who want to apply for a green card on their own. And this is called self-petitioning. Now, this means you can apply for a green card as an individual, whereas normally you need a U.S. company to sponsor you for a green card. Now, you may also be familiar with the EB1A, which is another category that allows self-petitioning for people who have quote-unquote extraordinary ability, of the people who are of one of the small percentage that have reached the very, very top of their fields. By contrast, for the EB1A, though, the EB2 NIW is a little bit more approachable. The EB2 NIW can be a viable option for a wide variety of professionals who are at various stages of their career, even if they're not among the very, very top small percentage of professionals who have reached the top of their fields, who can nevertheless show that their work will make significant contributions to the industry or society. And we'll talk a little bit more about that. So let's talk first about the threshold requirement to qualify for the EB2 category, as a whole. So this applies to not only NIW petitions, but for all EB2 applicants, you need to meet the threshold category first. So there are 2 ways to meet the threshold requirement. The first is to show that you have an advanced degree. And now, what is the definition of an advanced degree? It means a master's degree or above. So definitely, if you have a Master of Science degree, a Master of Arts degree, you would qualify for that. But even professional degrees, such as a JD, a Juris Doctor, or a MD, a medical doctor, those types of degrees can also qualify as an advanced degree because you need a bachelor's degree in order to gain admission to those programs, right? So, and another common degree that we use is the MBA, a Master of Business Administration. If you have an MBA, you can qualify as someone who has a master's degree, a master's level degree. Now, what if you don't have a master's level degree? What if you don't have an advanced degree? What if you have a bachelor's degree and if you have 5 or more years of progressive work experience in your field? You can also be considered as someone who is equivalent to an advanced degree professional. So instead of showing that you have a master's degree, you can show that you have a bachelor's degree plus over 5 years of full-time progressive work experience following your bachelor's degree. And it needs to be in the same field, and the work experience needs to be progressive. And what does progressive mean? It means that you have been asked to do increasingly senior and more complex duties and responsibilities as time went on. Now, this can be shown by changes in salary, this can be shown by changes in titles, and importantly, this should be shown by changes in your duties. And how would you prove that? You would need to present a letter from your previous employer on company letterhead that confirms that you had this full-time experience and also that your duties have changed over time. So you do need to get those employment confirmation letters from your previous employers if you're going that route to prove that you have the equivalent of an advanced degree by showing a bachelor's degree and progressive 5 years of full-time experience following your bachelor's degree. Now, the other way to meet the EB2 threshold is by showing that you have exceptional ability. Now, exceptional ability is defined as ability that is, quote unquote, a degree of expertise significantly above that is ordinarily encountered in the sciences, arts, or business. So one thing not to be confused about is exceptional ability is very different from what we say is extraordinary ability, which requires someone to be of a caliber at the very few percent that is at the very top of their fields. Now, exceptional ability does not require that. You only need to show that you are operating at a level that is significantly above what is ordinarily encountered. Now, how do you prove that you have exceptional ability? You do need to be able to show at least 3 out of the 7 enumerated evidences that is listed here. And this includes things like any related degree. It doesn't need to be a bachelor's, it doesn't need to be, a master's, but if you have a diploma or certificate from, somewhere that's related to your area of extraordinary ability, you can include that. Also 10 years of full-time experience, that can be another form of evidence you can qualify. Any related licenses, that you need to practice in your field, membership in professional associations. And importantly, you do need to show proof of recognition that you have received in the field for outstanding achievements, such as awards won, original contributions, such as, innovations patented in published in patents, or if you've authored, publications in your field that have been cited a high number of times, those types of corroborating evidence can show that you have received recognition from other experts in your field for your outstanding achievements. And that's the type of evidence that they're looking for to really see that if you're someone who has a degree of expertise that is significantly above what is ordinarily encountered in the sciences, arts, or business. And another popular category of evidence to submit is high salary. If you receive a higher salary than the average in the field, you can use that as one of the 3 out of the 7 criteria to show that you have exceptional ability in your field. Now, then, once you show the government that you meet the threshold requirement for the EB2 as a whole, then the other challenge is to demonstrate that your application qualifies for a national interest waiver. And the reason why we need to do this is because ordinarily, even if you have exceptional ability, even if you have an advanced degree, that does not mean everyone gets to qualify for an NIW. The normal pathway towards a green card is to have a U.S. company sponsor you, right? And so what the U.S. company does is they test the U.S. labor market and see if there is another U.S. worker who can take your position who is similarly qualified. And only if there cannot be a U.S. worker that can be replaced, then the foreign national is, allowed to be sponsored for a green card. So that's the ordinary, labor certification requirement that the U.S. government, imposes to protect the U.S. labor supply. However, if someone qualifies for an NIW, they're exempt from that requirement, right? So it is a privilege that is given, right? So in addition to showing that you meet the EB2 threshold, you need to prove that somehow your case merits the national interest waiver, because the ability to self-petition is sort of a privilege, an exemption that is given to people who meet those requirements. So what are the requirements? It is the 3-prong matter of Danaher criteria that was promulgated in 2016. The first criteria is that the foreign national must be able to prove that their proposed endeavor in the United States has substantial merit and national importance. Now, what does that mean? Now, substantial merit can be proven in a wide variety of fields, including, arts, sciences, business, and even culture. Now, national importance. The way to prove national importance is that the government will really look at what is the prospective impact of the work that the foreign national proposes to do. And endeavors that have national or global implications in a particular field because it improves best practices in the field, for example, medical advances or improved manufacturing processes that really not only will benefit your immediate employer or your immediate clients, but will end up kind of pushing forward the envelope for the industry as a whole, with new technology, new ways of doing things that are more efficient, that other experts can also, adopt and improve their practices. Those kind of innovative contributions to the field is what the government is looking for in terms of national importance. And if those innovations really help the US go further in meeting its goals. For example, there are some policy goals that the US government, promulgates in executive orders or legislation or things like that. For example, environmental sustainability is one of those, priorities by the government. And you can find evidence of this in, government announcements and government policies, and really looking at where the government is investing in at this particular period of time. And, critical technologies such as AI or semiconductors or critical infrastructure, for example, those are also some of the areas that the government really thinks is important for national security and the interests of the US. And if you can show that your work in your particular field really helps the government reach its goals in a significantly, faster timeline, or, in a significantly, better way, then those types of endeavors really would be favorable for meeting the first prong, that your work has substantial merit and national importance. Now, for the second criteria, which is the foreign national must be well positioned to advance the proposed endeavor. Now, that really looks at the individual himself or herself that is being, petitioned for the NIW. And you would, you would look at your education, you would look at your experience, and really provide evidence of your record of success on similar endeavors that really give you the know-how and specific insights that you need to advance the endeavor that has national importance. So they're really looking at the individual, and the focus is on the individual's past record of success. And finally, the third and final requirement is that, on balance, the applicant must be able to show that it will be beneficial to the United States to waive the labor certification requirement for that particular individual for that particular case. And there can be a variety of ways to argue this. The first way is to focus on the broad benefits of the applicant's proposed work in the United States. So, for example, if you're developing new technology that not only benefits your immediate employer or clients, but can be, used by other experts in the United States to really improve the way that the industry is doing things as a whole, then the proposed impact of this endeavor is broad enough to outweigh the ordinary benefits of, saving one spot of a job for a US worker, and giving it to the foreign national. So having this balancing act is important, where you would emphasize the broad systemic benefits that really outweigh the ordinary benefits. The other strategy you can take is to talk about your irreplaceable skills. So that would be emphasizing the second prong, well positioned to advance the proposed endeavor. Maybe you have accumulated experiences and know-how that cannot easily be replicated by another worker with minimum credentials. So you can have expert letters speak about what particular skills that you have that cannot easily be replaced. And the third way to argue the third prong is in special considerations, such as, if you're an entrepreneur and you're running your own business, and if you will be creating multiple jobs, a high number of US jobs by running your business, then that in itself is a compelling, countervailing benefit to, the ordinary benefits of a labor certification process, really saving one spot for one U.S. worker, you can definitely make a strong argument that there will be, greater countervailing benefits of job creation through your business endeavor as opposed to the ordinary benefits of a labor certification. All right, so let's talk a little bit more specifically about, a case where an entrepreneur is applying for the National Interest Waiver. How can the National Interest Waiver be used for entrepreneurs? Now, the first thing to note is that the previous case law really focused on the physical scope of the endeavor. So they were really asking for endeavors that are national in scope. So if an entrepreneurial endeavor was limited to one particular region, one particular state, that was not favorable for, being granted the National Interest Waiver because the previous case law required, a broad geographic scope of how your endeavor will impact, the nation. Now, the new case law, matter of Danazar, moved away from that. So beginning from 2016, after the promulgation of the matter of Danazar and the new criteria, even endeavors that are focused on one geographic area can be found to have national importance. So for example, if you're an entrepreneur and you're bringing in a large-scale development project, but if it's only contributing to developing one particular area. Let's say you are revitalizing an economically depressed area in a particular state, in a particular locality where the unemployment rate is high. Now, that can also qualify as an endeavor of national importance, even if the impact is concentrated in one particular region, one particular state. So that is definitely one advantage that entrepreneurs now have when they are preparing an NIW application. If you can show that your work will revitalize a particular economically depressed region in a significant way, you can still qualify for an NIW, even if your work does not impact the nation as a whole geographically. Another way you can show national importance under the matter of Danazar criteria is to show that your particular endeavor will have a broad impact to your specific field. And for example, the case law talks about medical advances or advances to manufacturing practices, for example. So if you're working in a very specific branch of science or technology, and if you're proposing to engage in research and development that could introduce new discoveries that are scientifically important or important for that particular narrow field, those could also qualify as endeavors that have national importance, even if it's, only relevant to your particular field. So as long as your endeavors are impacting your field in a broad way, the actual physical, physical impact, the geographic scope of your endeavor does not need to be nationally in scope. So that is one very important change that came about with matter of Danazar. Another advantage for entrepreneurs that came about with the new case law is that the case law specifically recognizes that a green card through NIW could be a good solution for entrepreneurs who cannot practically go through the labor certification process. Right. So the case law specifically recognizes that many entrepreneurs have ownership interests in their company, and therefore it is practically often not possible to use the conventional employer sponsorship route to obtain the green card. And the case law also recognizes that entrepreneurs create jobs. So in that way, Congress's interest in making jobs available for U.S. workers could be better served by allowing an entrepreneur to develop their business as opposed to making it difficult for the entrepreneur to come to the United States to work by imposing the labor certification requirement unduly in that scenario. So in conclusion, matter of Danazar, which is the new case law that was promulgated for the standard for NIW, specifically notes that entrepreneurial work can lead to the NIW, a green card through NIW, and states that even the planned venture does not need to be successful as long as the applicant can show that it is plausible that the entrepreneurial venture can succeed, and of course can show that the person is well positioned to advance the endeavor. All right, so now let's shift gears a little bit and talk about timing and other strategic considerations when you are considering moving from a non-immigrant visa to a green card through the EB-2 NIW. Now, one thing to note is that the green card application has two steps. And you may already know this, but the first step is the underlying petition, which is, in this case, the I-140, which determines if you are eligible for the green card under that particular category in the first place. And the second step is the actual application for the green card. So the I-140, the I-140 itself can be premium processed. So if you use premium processing for the I-140, you can get an action from the government within 45 calendar days. So the action can be either an approval, it could be a request for evidence, it could be a notice of intent to deny, but the government will commit to getting back to you regarding your application within 45 calendar days if you use premium processing. If you use regular processing, it means your I-140 application could be pending for approximately a year. Now, once you have the approval of the I-140, you can then move forward to apply for a green card based on that approval. And this can also take about a year. So you can, if you're in the United States on a different non-immigrant visa, you can apply to adjust your status to a green card holder by filing what is called the I-485. If you are outside of the United States, you can apply through your home country consulate for an immigrant visa. And you submit what is called a DS-260 and schedule an immigrant visa interview. And once you pass the immigrant visa interview, you will get a immigrant visa in your passport, and you will land in the United States with that immigrant visa, and that will be, and your green card will be mailed to you in your U.S. address. So those are the two ways you can process the green card, and that process can also take about a year to process. It is not a quick process. Another thing to note is the EB2 category is backlogged right now, which means there are a limited number of immigrant visas and green cards that can be issued every year, but there are more applicants who are qualified who apply for the green card than there are visas available. That means you need to wait in line basically for a time. Now, this not always used to be the case. Before November 2022, the category was current. And what does it mean when a category is current? It means you can simultaneously apply for your I-140 and also apply for your I-485 if you're already in the United States. If the category is current, you can start the green card process simultaneously with your underlying I-140 petition. But as of now, for everyone in the world, there is a little bit of a backlog. So this can cause further delays, to the ultimate timeline on when you will have your green card in hand. So definitely a good idea to talk to your attorney to make sure you understand the exact timelines involved, so that you can plan out your green card process in advance. Now, let's talk a little bit about underlying visa status. So one thing to really remember here is the NIW application is an immigrant petition. And to a certain degree, it means that you are interested in immigrating to the United States, and it can be such an expression. So if you are on a non-immigrant visa that does not allow for dual intent. So dual intent means you can simultaneously have a non-immigrant intent to, work in the United States under an H-1B or L visa, for example, but you can also have a long-term intent to become an immigrant to the United States. For dual intent visas, that is fine. For non-dual intent visas, that is not okay. For non-dual intent visas, such as, a B1, B2 visa or F1 visa, student visa, those types of visas really scrutinize you for your immigrant intent. So if you have an I-140 that is pending, if you have an I-140 that is approved, that can be taken by a consular officer as an expression that you ultimately want to immigrate to the United States. So that can cause challenges when you're trying to renew, a B1, B2 visa, when you're trying to renew an F1 visa, or when you're, trying to extend a visa category like that. Like TN visas are one example where you may get into trouble at the border when you're trying to renew your TN visa, and the officer sees that you have an I-140 filed in your system, and they can question like, oh, you filed, an NIW I-140. Doesn't that mean you intend to immigrate to the United States? If so, that can really cause you a bit of a headache when you're trying to apply. So definitely speak to your lawyer. when you're considering applying for the NIW, because there could be timing considerations on when it is strategically beneficial for you to file a renewal of your underlying non-immigrant visa before you file the I-140. So then let's talk a little bit about the application process and what it involves. So as I mentioned before, there are two steps to the green card processing timeline. The first step is to file the I-140. And as I mentioned before, with premium processing, you could get an answer within 45 days. If you get a request for evidence, you are given some time to prepare your evidence and your explanation of why you meet the criteria, and then you submit it. And after you submit, the government will take another 45 days to look at your filing and render a final decision or any sort of response. And without premium processing, if you use regular processing, you will likely be waiting about a year to get an answer from the government for your I-140. Now, the second step is the actual green card petition, which takes the form of either the I-485 or consular processing, an immigrant visa application. So the I-485 is what is called the adjustment of status application. And you process this from within the United States. And you need to already be on a different non-immigrant status in the United States in order to be able to apply to adjust your status to a green card holder. And your priority dates must also be current for you to be able to file the I-485. So it is possible that you will get the approval for the I-140, but because the priority dates are backlogged right now, you could be waiting many months before you can actually file the I-485. And keep in mind that you need to continue to have valid non-immigrant status up to the point that you file the I-485. So that is another consideration on timing that you want to think about in advance. Consular processing. So consular processing for an immigrant visa means that you submit the DS-260 through your home country consulate, and you will schedule an actual interview with your home country consulate for the immigrant visa. This can also take about a year to process. Really depends on the workload of that particular consulate. It can be as quick as several months, but it can also be significantly elongated if the particular consulate has a heavy workload. So the other question is the category current? And I already mentioned this a little bit when I was, talking about the previous bullet points, but this has become an issue since the end of 2022. Every year, there is a limit in the number of green cards that can be issued under each category. And except for certain countries, the EB2 NIW category has always been current, but recently, well, not really recently now, since the end of 2022, this category has been oversubscribed for all countries, which means there are more people approved and applying for the green card under this category than there are visas available every year. So there's pretty much of a waiting period. Basically, you can think that you're waiting in line until your priority date becomes current, which means the date that is shown on the visa bulletin that month is earlier than the date your priority date is earlier than the threshold date that is published in the visa bulletin for that particular month. Only in that case, you can proceed with the green card application. And every year in October, a new batch of visas become available. That is the beginning of the fiscal year. So it is likely that there will be some changes, some forward movement in the priority dates closer to October. But yeah, with many things that the government does, there is really no guarantee on how the situation will improve. So on average, I would say my clients are seeing about a waiting time about a year after they get their approval of the I-140 until they can actually file their I-485 or immigrant visa petition. Right, so the last topic I will go over with regards to strategic considerations is adjusting status in the United States versus consular processing. What are the benefits and what are the disadvantages? So adjusting status in the United States, which is done by filing the I-485, as I mentioned before, allows applicants to continue living in the United States in the interim while the I-485 is processing. So this gives an independent basis for them to continue staying in the United States, even if they don't, extend their underlying non-immigrant status. So once you file the I-485, you can apply for what is called an EAD, an employment authorization document, by filing an I-7 I-765. And once you get the EAD, it is pretty much an open work permit. So you can work for anyone you want, or you don't even need to be working anymore, but you're still allowed to stay in the United States up to the point where a decision is made on your I-45 petition, which can take, about a year, right? Or even more than a year if the priority dates retrogress. So that can be a significant advantage for people who want to continue living in the United States while waiting for their green card to be processed. Now, the disadvantage of filing an I-45, the disadvantage of adjusting status in the United States is that there can be a period where you cannot leave the United States while the I-45 is pending. So, for example, if you file the I-45 and you also apply for a travel authorization document, but your travel authorization document is not approved yet, and your I-45 has been pending for like several months, and you need to leave the United States, to go back home for something or emergency. Now, if you leave the United States while you don't have travel authorization, and your I-45 is still pending, leaving the United States will be construed as you abandoning your I-45. So you will need to redo the whole application again. So that is one specific disadvantage that applicants have when they are choosing to adjust status in the United States, that there is a period of time where you could be stuck in the United States, basically. Now, so then let's talk a little about the other option, which is going through consular processing and applying for an immigrant visa through your home country consulate instead. So obviously the advantage of doing consular processing is that you're not bound by those rules, so you can continue to have the immigrant visa processing, but move in and out of the United States if you have a different non-immigrant visa that you can use. And if you can, continue to maintain your non-immigrant visa status, you can use that to move in and out of the United States. Or you can, wait for the whole process to, complete in waiting in your foreign country, in your home country itself. So you don't need to be in the United States while this whole thing is processing. So I guess the choice would really also depend on the applicant's preferences on where they would prefer to wait for their green card to be processed. One disadvantage of consular processing is that it does not give any independent status to continue living in the United States. So you do need to separately maintain a different non-immigrant status if you wish to continue living in the US. And that could be a challenge, right? Depending on, the type of visa that you're applying. Since, applying for, an immigrant visa, applying for an I-140, those are all expressions of immigrant intent. So once you have these wheels in motion, it could be more difficult to renew or extend other types of non-immigrant visas while those processes are ongoing. So there are risks in both sides. Definitely speak to your lawyer to determine the pathway that will work best for you. All right, so now let's shift gears a little bit and talk about some updated guidelines that were promulgated in 2022 that pertains to STEM professionals, individuals in sciences, technology, engineering, mathematics, and entrepreneurs. The USCIS has written those specific policies that relate to how those types of applicants can benefit from the NIW. So for the STEM specific guidelines, one thing to keep a note of is that the government has published what is called a critical and emerging technologies list, called the CNET list. And if a person has an advanced degree in STEM, and if the person is, proposing to do research that is related to advancing those critical STEM technologies in the United States, that would be very favorable in meeting the first prong, national importance, and also for well positioned. If you have the STEM degree and have related research experience, that could prove very favorable for meeting the second prong as well. So I can tell you a little bit of what technologies are included in the CNET list. Those include, advanced computing, advanced engineering materials, advanced manufacturing technologies, advanced sensing technologies, aero engine technologies, agricultural technologies, artificial intelligence, AI, autonomous systems, biotechnology, communications and networking technologies, such as 5G network technologies, things like that, data science and storage technologies, distributed ledger technologies, energy technologies, medical and public health related technologies, quantum science, semiconductor technologies, space related technologies. Those are all included in the CNET list. And if an applicant's STEM endeavor is related to advancing these technologies in some way through some research, either in industry settings or academic settings, that can be very favorable for meeting the first prong, national importance. So now let's talk a little bit about the entrepreneur-specific guidelines that was published by USCIS. So what you need to know here is that the government specifically recognized that entrepreneurs usually don't have the traditional variety of evidence that, a PhD graduate would have, right, in terms of proving national importance and well-positioned. So, for example, an entrepreneur would not usually be expected to be authoring academic publications and, garnering a high number of citations and things like that. An entrepreneur would not really have a Google Scholar, for example, which were the traditional metrics that the USCIS used to use when judging the substantial merit and national importance of a proposed endeavor. So the government published guidelines on what kinds of alternative forms of evidence that entrepreneurs can use to support that their endeavor will indeed have a broad impact to support national importance. So, for example, significant media attention on either the petitioner or the petitioner business, or both. Those can be very helpful to show that the industry is really paying attention to what the entrepreneur is doing. That can be helpful to support a prospective impact that is broad enough to support national importance. What about awards or grants? If the business or if the petitioner has received awards or grants from government entities, for example, small business, accelerators or incubators, for example, those kinds of investment can be used as, third-party objective evidence that corroborates that the impact of the petitioner's business will be broad and that it will have a positive impact to the industry as a whole. Letters from institutional investors, venture capital firms, letters from government agencies supporting the individual's business project can be very helpful in, establishing the endeavor's substantial merit and national importance. And evidence of revenue generation and a strong business plan or a strong valuation that can show that the business has the potential to create a substantial positive economic impact, that can also be helpful in meeting the national importance prong. And what about well-positioned? So well-positioned can now be supported by submitting proof, of the petitioner's ownership and critical role in the U.S.-based business entity. Similar to, the ordinary NIW applications, you can submit your degree, certifications, you can submit expert letters describing your experience and really providing detail about the past projects that you have done and what impact those past projects has had in your particular industry or field. That can help support that you're well positioned to drive the business endeavor to success. Receipt of government grants can also not only, support national importance, but it can also support well-positioned because you're the one who applied and received those grants. If you authored intellectual property that is being used by the venture that you're leading, that can also, be persuasive evidence that, you're the one who's best positioned to drive forward this endeavor. And a history of revenue growth that can also support well-positioned because you're the one who created those figures. So definitely helps to see those alternative types of evidences that entrepreneurs can now rely on to support their NIW case. All right, so let's then talk a little bit about the documentations that usually the government will expect to see when they are evaluating a NIW application by an entrepreneur. So the first thing to note by way of documentation is you need to include the proof that you meet one of the threshold requirements for the EB2 category, which, as I mentioned before, can either be met by showing that you have an advanced degree in your field, which is defined as a master's degree or above, or that you have exceptional ability in your field of endeavor. And if you can show that you have an advanced degree, you do not need to show exceptional ability in addition. You just need to meet one of these criteria, although in some cases you may qualify for both. Now, one thing to note is that if your master's degree, if your advanced degree, or master's or bachelor's, if you're also using 5 years of work experience, if that degree is from a foreign institution, if it's not a US institution, then you should get what is called a US education equivalency report from a accredited licensed evaluator to confirm that indeed your particular foreign degree is equivalent to a US degree for that level. So you do need that if it is not a US degree. So, and if you are using exceptional ability to meet the EB2 threshold, you do need to show evidence meeting at least 3 out of the 7 criteria that I described before. And also, sufficient evidence of recognition for your achievements that show that you are someone who is operating at a level that is significantly above what is ordinarily encountered in the field. So that is kind of a qualitative assessment as well. The expert letters will play a big role in corroborating that. Now, once you have prepared and submitted the documentation showing that you meet the threshold requirement for the EB2, the next step is showing evidence that you qualify for the National Interest Waiver. Because, as I mentioned before, even if you qualify for the EB2 threshold, that doesn't mean you automatically qualify for the National Interest Waiver. Normally, for people who qualify for the EB2 category, they go through what is called the labor certification, through a US, job offer and a US sponsor. But if you can show that you meet the NIW 3-prong criteria promulgated by matter of NSR, you can be exempt from that requirement. So it is definitely more important. I would say I wouldn't say more important, but I would say the meat of the petition will really be dedicated to proving that you meet the NIW 3-prong matter of NSR criteria, and typically a volume of evidence is submitted to support that. So what are some of the examples of documentation you can collect? So with regards to substantial merit and national importance, definitely evidence that your particular endeavor and the field that you're contributing in, it is a matter of policy priority for the US government. That would be helpful to include. And that can be supported by government announcements, things like executive orders, investments that the government has made. That is, you can search for news articles that talk about things like that. White House reports, press releases, things like that can really show that a particular area that you're contributing in is an area that the US government finds important. So government pronouncements are very important in that regard. For entrepreneurs, a comprehensive business plan is strongly recommended to show that your endeavor will have a substantial positive economic impact to the economy as a whole and to your particular industry. You really want to not only talk about the economic impact that you stand to make in terms of revenue generation, tax revenue generation, US hiring. Those metrics are very important, but also you want to talk about the qualitative improvements that you're making to your field as a whole in terms of advancing best practices. For example, if you're operating in a particularly critical technology industry, such as AI or things like that, really talking about what your offerings do to improve, the level of competitiveness of, the industry as a whole in the United States. So if it will help the US gain leadership in those particular critical industries, then that can be very positive for meeting the first prong, national importance. Expert letters. Expert letters are another very important part of an NIW petition. An NIW petition tends to be very subjectively, evaluated, because what is in the national importance, right? And so it is very important to develop the right narrative through the expert letters, really providing concrete details on both what you're planning to do in the United States, what is the expected impact of those endeavors that you plan to do, and also having expert letters that describe what you've done in the past and what are the projects that you've done in the past that have had a broad impact to the field, and how does that make you well positioned to advance this endeavor. So you do need to have a mix of expert letters that both confirm your past achievements and also expert letters that can confirm the prospective impact of your work in improving best practices in the United States in a particular area and explaining to the officer why they're important. And coming from the words of the experts is important, because if they won't necessarily trust what the lawyer is saying, or they won't necessarily trust what the applicant is saying. But if those words are corroborated by the testimony of multiple leading experts in the field who have decades of experience in the United States, and we also typically include the full curriculum vitae, the full resumes of each expert who are providing that testimony. So that will really strengthen the credibility of the assertions that the applicant is making on what impact their work can have in the United States. What else? The applicant's resume, degrees, proof of professional accomplishments, that yeah, and definitely objective evidence in addition to the expert letters is what the government is looking for to really see what the applicant has done in the past, and evidence of industry interest, evidence of government interest in those projects really helps drive forward the case, to make it a strong case. For example, if the applicant was invited to industry conferences to talk about their particular achievement, to talk about their particular offering or technology, those types of things can help prove that not only the applicant's work benefits their immediate clients, but also other experts are actively listening to what the applicant has to say about this new approach, and that can have a broader ripple effect to the industry, in terms of improving best practices. So that can be a good way to show a broad impact and also show well positioned as well. Past history of success. So the thing about past history of success is not only do we want expert letters to explain what the applicant has done, we really want to make sure to include third-party objective evidence, such as press releases about a particular business project, or internal reports talking about what the project was about. So really combining the objective evidence with the expert letters is a good strategy, because sometimes the USCIS won't just take the testimony of experts to be dispositive. So having as much corroborating evidence as possible would be good for the NIW. Finally, specifically for entrepreneurs, you can include proof of contracts with leading industry actors in the United States to show interest in their work. Letters of intent can also help, and evidence of startup capital. If you have received angel investment or if you have received venture capital investment, definitely I would suggest including proof of those to show that you have had progress in your particular business endeavor, and that the business endeavor has attracted interest in terms of investment from relevant entities in the field. Those can help in all three prongs. All right, so the last topic we will go over is we will discuss an example of a national interest waiver applicant who met each of the NIW criteria. So the case study that we'll be talking about is of an entrepreneur who proposed to set up a small consulting firm focused on doing projects with relevant veteran service organizations for the purpose of improving veteran services and care for wounded warriors, and really to arrange programs that can help reintegrate wounded warriors back into productive society. So how did he prove substantial merit and national importance? So for substantial merit and national importance, this person provided a very detailed and well-researched business plan. And the business plan really explained the gaps in veterans care that he saw in the United States as a whole, and described how his offerings will materially improve this reality. And with this business plan, the applicant also included letters from prospective clients and prospective partners who were relevant, organizations in the United States covering the field of philanthropy and veterans care, really describing how this program stands to materially improve program offerings that are that are available at present. And even government entities were able to provide letters of support for this particular business plan. So that ended up being very persuasive for the government. In addition to the business plan and the letters, the applicant was able to submit government reports, news articles, and also other types of letters that really described why there were gaps in veterans care, and showing that there was significant public and governmental interest in this particular work. And now, how did this person prove that he was well positioned to advance the proposed endeavor? So the fact that really strengthened this application was that this person had a very remarkable success record in related past endeavors in the UK, where he was from. And to substantiate that, this person received letters from very senior officials from government who had worked with him in the past. So this person had played a leading role in developing and implementing initiatives to connect public and nonprofit organizations in the UK and the US to benefit wounded warriors and veterans welfare. And really had really had remarkable success in connecting wounded warriors to productive job opportunities. And one of the letters described how hundreds of wounded warriors were able to find productive job opportunities directly because of the programs that this person had designed and implemented. And another testimonial letter talked about how tangibly his work enabled millions of dollars to be productively connected between, charitable organizations and veterans priority organizations to really make it into a reality. To put these dollars into productive use through tangible initiatives. So those types of very specific testimonial letters really helped strengthen the petition in terms of how well positioned he is, and to drive forward similar initiatives in the United States. And now let's talk about the third prong, on balance. How did this person prove that it was beneficial to the United States to waive the labor certification requirement? Now, one thing to note is that all three prongs need to be satisfied in order to, be approved for the NIW. So you need to meet both national importance, well-positioned, and also on balance. And now, for this particular case, the government mentioned how, being an entrepreneur, this person will be self-employed, and it will be impracticable for him to use the traditional methods of labor certification to, get a green card to be able to do this work. So the bare fact that this person was an entrepreneur was one positive aspect of passing the third prong. Now, another thing that the government really focused was the outsized value, the immense, systemic, broad value of improving programs and assisting organizations that supported the welfare of U.S. veterans and wounded warriors, which was definitely, larger in scope than the ordinary benefits of the labor certification, which is to, reserve one, job spot for a U.S. worker. Definitely the systemic benefits were much greater and much broader than that. So even if qualified U.S. workers were available, the government found that granting the NIW Green Card for this particular applicant would, produce more benefits to the U.S. as a whole. Oh, okay. So I believe that is all we had for today. We can answer questions if there has been any. I am looking to see if any questions have come in using the Q&A function. I don't believe we have any. So if not, then I will thank you everyone for your time joining us for this presentation today. I hope this was helpful. And we will be sending out the resources to everyone, as I mentioned before at the beginning of the presentation. And if you'd like to discuss your case further with me or any other experienced attorney, definitely feel free to reach out to us using the link that we will provide. Thanks, everyone, and hope you have a great day.